Thank you, Madam Chair. The next bill before you is Second Substitute House Bill 1470, sponsored by Representative Ortiz-Self, which has to do with private detention facilities. The bill passed the House floor 58-39. By way of background, a private detention facility is a detention facility operated by a private, non-governmental, for-profit entity and operating pursuant to a contract or agreement with a federal, state, or local governmental entity. Legislation from 2021 prohibited the operation of a private detention facility, but exempted certain facilities and grandfathered facilities operating under a valid contract in effect prior to January 1st, 2021 for the duration of that contract. Additionally, last session, certain records of incarcerated individuals at the Department of Corrections were made exempt from the Public Records Act, such as body scanner images and certain health information. The bill before you has 5 main components. First, the Department of Health must adopt rules and standards providing sanitary, hygienic, and safe conditions for detained individuals, specifically clean living areas, laundry, basic personal hygiene items, a nutritious and balanced diet with proper food handling, safe indoor air quality, heating and air conditioning equipment, and an infectious disease control program. Second, DOH must conduct unannounced routine inspections of food service and handling, investigate complaints, test water and air quality, review nutrition levels, and post inspection results online and in a conspicuous area in the facility in English and in languages spoken by detainees. DOH may delegate food safety inspections to the local county health department and must adopt rules. Also, the Department of Labor and Industries must inspect workplace conditions, including work undertaken by detainees. Third, operational requirements are specified for private detention facilities with contract effective dates after January 1st, 2023. These requirements are outlined in the bill report and relate to commissary access, telecommunication services, in-person visitation, solitary confinement, responses to sexual violence and harassment grievances, mental health evaluations and medical care, and emergency response. Fourth, the bill creates a private right of action for detained individuals to recover monetary damages for negligent and reckless violations of this act. In addition, a civil penalty of up to $1,000 per violation per day may be imposed against an owner, operator, contractor, subcontractor, or employee of a private detention facility. If the civil penalty is not paid to Department of Health within 15 days, the Attorney General may bring an action to recover the penalty, and those recovered funds must be deposited into a newly created humane detention account created for costs associated with the Attorney General's enforcement and recovery actions. The Attorney General is also generally authorized to enforce violations of this act and agency rules and investigate complaints. Lastly, the Public Records Act exemption for incarcerated individuals at DOC applies to detained individuals at private detention facilities, meaning disclosure is prohibited. A fiscal note is available showing $1.4 million per biennium, mostly for costs for Department of Health to conduct inspections, do rulemaking, and staffing. That concludes my very long briefing. I'm sorry. And I'd be available for questions.
Any questions for Kelsey? Yeah, Senator Wilson.
Thank you, Madam Chair. Just real briefly on here, because I read through the bill report on the bill. Are there currently the same standards set aside under operational standards and health and workplace inspections for public? For those incarcerated individual facilities?
Sure. I do know Labor and Industries does have jurisdiction to go into Department of Corrections and review for workplace violations. I believe there was like a fine for a tuberculosis outbreak at Department of Corrections. And there are various state agencies that have inspection authority, and as I mentioned in the bill report, so Department of Health can go into hospitals, look at transient accommodations, and I think migrant farm worker housing facilities, and DSHS has authority to look at long-term care facilities and conduct inspections of those.
Follow up real quick. I'll be brief because Representative Ortiz, I should have asked this for you, but so there is similarities and mirrored potential regulations already in place with public facilities. That's a way to rephrase that.
I will defer to the sponsor. I'm sure there's some overlap, and I can,
Okay, I apologize. Sure.
And I would say also, if we need to do follow-up, we're happy to do that, I think. Yeah, no, that's fine. Have we heard this bill before, Kelsey?
Not this specific bill, Madam Chair.
So this is not a companion bill, it's a
Oh, yes.
bill
No,
that-
this is a new
and
bill.
we have not heard it last session. But we did hear a bill on private prisons and detention centers in past legislative
2021,
sessions, but
yes.
not around the same content as this bill, correct?
Correct, Madam Chair.
Awesome. Representative Ortiz-Self, welcome to Human Services in the Senate.
Thank you so much. Madam Chair, Ranking Member, members of the committee, thank you for hearing this bill. For the record, Representative Lillian Ortiz-Self from the 21st Legislative District. And yes, we have heard a private detention bill in the past. The bill came about as we looked at what was happening in our state and across the nation with private facilities and how they ranked it as far as services being provided. And the conclusion was that nobody should be making a profit off of our most vulnerable people. And that is exactly what was happening. There was a conflict of interest. There were cuts across the board to food, safety, et cetera. And across the nation, every other country, every other state was complaining about the same thing. And we made a strong statement that in the state of Washington, you should not be making a profit off of the most vulnerable. And we proceeded with that. That bill currently is under litigation. And so as we don't know what's going to happen to that, we thought that at the very least, we need to set standards. We need to set standards to what Senator Wilson just mentioned that is comparable to what is happening in other public facilities. In other public facilities, we don't have hunger strikes. We don't have the, especially during the pandemic, we don't have people sharing one mask for 2 weeks and 3 weeks at a time. We don't have them being denied health care and visits to the sick room. We don't have them temperatures in there that are so cold that people can't sleep or operate, et cetera, et cetera. The food is not comparable. Senator Wilson, I don't know what it takes for someone to be so desperate that they go in hunger strikes, but repeatedly, year after year, that is what is happening. We have people so desperate and the conditions so bad that they continue to go into hunger strikes, continue to just give up hope because of the terrible conditions. And the worst part is that a certain facility in our state knows we have their eye on them, knows that we have filed to close the center, knows that we are trying to get in for them to prove us wrong. And there's been no cooperation. There has been no meeting us halfway. There has been nothing to fix what they're doing. They continue to get worse and worse, and we continue to have people in desperate need. This bill is simply saying, if you're going to do business in the state of Washington, you're going to do it with the same standards that we require our other facilities. You're going to make sure that the food is edible. You're going to make sure that when people are sick with bronchitis and can't breathe, you're going to let them into the health center. You're going to make sure that some of these basic human needs are being met, or you shouldn't be doing business in the state of Washington. We are setting a standard for our state that all people, regardless where they come from, should be treated with the humanity that every single person deserves. That is what this bill is doing, and I urge your support.
Thank you so much. Any members have questions for Representative Ortiz-Self? Thanks for being here. Oh, yes, Senator Warnick.
Thank you, Madam Chair. So Representative Ortiz-Self, is there only one facility in Washington that you're talking about, or are there more than one?
Currently, there is one, but this bill sets the standard that any private facility that we do business with will adhere to the same standards. So opening it up for any future private detention facilities in our state.
Thank you.
Any other questions? All right.
Thank you very much.
Thank you so much, and thanks for being here today. All right, we're going to, next up, I see Representative Dye here, so we're going to move to House Bill 1570, Private Detention Facilities. And Madam Vice Chair, panel number 1, please.
Thank you, Madam Chair. We do have 3 panels in person. We have Manuel Abrego, Maru Moravelapando, and Paul Benz.
Good morning.
Morning.
Manuel, would you like to begin?
Yes. Chair and member of the committee, my name is Manuel Abrego. I am here today to testify in support of HB 1470. I have the opportunity to testify before this committee on a different but related bill to civil detention. At the time, I explained that I am an expert on this issue, but not by choice. I am a co-director of La Resistencia, an organization dedicated to fighting the injustice of civil detention. Throughout my life, I've been in civil detention facilities twice, starting at 16 years old and was held at a facility for juveniles. Then in 2016, when I was held at the Northwest Detention Center for over a year and a half, as I waited for my immigration case to be resolved. I support HB 1470 because it is dangerous to ignore this bill. On Friday, February 2nd, detainees at the Northwest Detention Center began a hunger strike and were joined by over 150 people. Their demands were simple: real food, regular meal times, clean clothes and spaces, adult-sized blankets instead of child-sized blankets, appropriated medical services. GEO responded by sending in a tactical unit that showered protesters with tear gas and pepper spray. Detainees have no power and were pushed to the brink. They have to use their lives and their wellness to challenge GEO's inhumane treatment. Private civil detention-run facilities can treat people however they want. There is no authority that stops them from serving rotten food or from giving dirty clothes. There is no officials that stop them from throwing people into solitary confinement as a punishment. There is no authority that stops them from harming us. You have the power to change this. When I was held at the Northwest Detention Center and organized a hunger strike to demand better conditions, I was thrown in solitary confinement for weeks. I was powerless, and now I am out here asking you to change things. Don't force immigrants to use their life as a bargaining chip. This bill will make it obligations for privately owned detention facilities to create a safe and healthy environment and provide people with the basic dignity of clean clothes and warm, edible meals. I urge you to vote in favor of HB 1470 to protect Washingtonians in private civil detentions and to ensure every private facility held accountable for their treatments of detainees.
Thank you, and thanks for being here again.
Thank you.
All right, next up, Maru. Good morning.
Good morning. My name is Maru Mora Villalpando. I'm also a member of La Resistencia. Thank you for this opportunity. I'm here in support of HB 1470. Business operating in our state must be meeting basic safety and health standards, included private detention centers such as the one in Tacoma. Our state agencies and local health departments should have the right to inspect unannounced by any of these private detention facilities and ensure that the basic public health and safety standards are met. Most long-term detention facilities right now are under these basic standards. Private civil detention facilities in our state should not be afraid of being inspected if they are meeting those basic standards. In just 1 month, as it was mentioned, in this private detention center, we saw people detained being gassed for speaking up, a person attempting suicide to bring attention to their plight for better conditions, empty promises to better food that's being served, a person detained being beat up by 2 private guards for accepting the gift of a sandwich by another person detained, and countless more basic human conditions violations. This is just one example of why HB 1470 is a very urgent need in our state. We're asking for very simple, basic things anyone should have access to: clean water, clean clothes, edible and nutritious food, no solitary confinement, etc. And the state has an obligation to meet these standards. We as the state, we cannot turn away. The detention center is here in our state. Our state agencies, our governor, you all of us, we're responsible for this. So we need to address this situation. We cannot look away. It is not right. And until this place for us is gone, we all have the obligation to make sure that people there are not forced to go on hunger strike, are not sent to solitary confinement because they speak up, are not gassed because they organize to bring attention to the violations they're suffering. So we're talking about human beings and their safety under someone else's custody. Please vote yes on HB 1470. Thank you.
Thank you very much, and thanks for being here today as well. Paul, you made it.
I did.
Good morning.
Good morning, Chair Wilson, Ranking Member Benke, committee members. I'm Paul Benz, barely. Speaking on behalf of the Partners for Social Change, testifying in support of Substitute House Bill 1470. We've been working with our prime sponsor, Representative Ortiz-Self, that will bring about what we hope to be better living conditions and a private right of action for those detained in our private detention facilities in this state. The bill creates baseline human right types of standards such as clean air, clean clothing, healthy living spaces, and nutritious food. When private detention centers fail to meet these basic human rights, it is indeed the state's duty to step in and intervene, to do oversight and accountability. This bill also includes civil penalties when these abuses do occur, which we obviously support. When abuses occur and are documented, we need the state to be able to take swift action to enforce these basic health and safety standards. We urge your support of this bill and to move it forward. Thank you.
Thank you very much. Thanks for being here today. All right, next panel, Vice Chair Kaufman.
Thank you, Madam Chair. We do have Megan Kelly Stallings and Lauren Jenks.
So Megan, I do believe you are virtual, so why don't we have Lauren, you're here in person, so come on up. We'll go for you first, and then we'll find Megan and have her go next.
Wonderful.
Good morning, you can begin.
Good morning. Thank you, Chair Wilson and committee. For the record, my name is Lauren Jenks. I'm Assistant Secretary for Environmental Public Health at the Washington State Department of Health, and I'm delighted to provide testimony on this important bill. This bill closes a gap in authority by clarifying the role of the department in assuring safe and healthy environments for some of the most vulnerable Washington residents. We have been working with Representative Ortiz-Self and are very grateful for her negotiations with us and accepting some of the amendments that we put forward. We know that there's one more technical fix coming to repeat the definitions of private detention centers in other sections of the bill, just to fix a little bit of unclarity there. Senator Wilson, you asked if these standards are the same as in public detention centers, and these standards are broadly described in the bill, and it gives the department authority to write rules. So when we write those rules, we do intend to look at rules that are already written, right? Like for that address Department of Corrections, health and safety standards. And in addition, we do regulate temporary worker housing. I think some of those may be applicable. It wouldn't be something that we create out of thin air, right? We would be looking to harmonize with the other rules that are there. Like other crucial public health work, this bill does require an investment of state funds, and it is to create the health and safety standards that we just talked about, and to inspect and to follow up on findings and then complaints that we may receive. Since this is an investment that has not been considered in the governor's budget, we have signed in as other today, and I'm happy to answer any other questions.
Awesome, any questions? Yes, Senator Warnick.
Thank you, Madam Chair. And this might have been answered already, but who licenses these facilities? Does the state do that? Does the Department of Health do that? Is it a federal license?
This is a federal facility.
Okay. All right. Thank you.
Mm-hmm. Thank you very much.
Thank you so much. Next, I do see that Megan's on. If you turn your camera on. Good morning.
Good morning.
You may begin.
Yes, thank you. Good morning, Chair Wilson and members of the committee. My name is Megan Kelly Stallings, and I work as the governor's legal advisor on immigration issues. I'm here today to testify as other and to provide some background for this bill, some of which has been touched upon already. As was discussed earlier, the legislature passed House Bill 1090 back in 2021. That bill was intended to prevent private detention facilities, with a few exceptions, from operating in Washington state. HB 1090 had been modeled on a California law, which was in the early stages of litigation at that point, But this past fall, the Ninth Circuit Court of Appeals found a major part of that California law to be unconstitutional on the basis of intergovernmental immunity, meaning that a state, could face legal challenges in trying to prevent the federal government from entering into a contract, even within the state of Washington. However, the Ninth Circuit Court did clearly delineate a state's broad authority to enforce health and safety laws within private detention centers operating within their state. And I believe that's what this current bill is trying to do, based on that explicit guidance provided by the Ninth Circuit. So even though HB 1090 is still valid at this moment, it's clearly threatened under this precedent. And HB 1470 provides explicit guidance under the assumption that private detention facilities may still be around in the future. I also wanted to state that the governor's office is working with agencies on amendments and will introduce those as soon as they're ready. State agencies, including DSHS and DOH, expressed concerns regarding the unintended application of this bill to facilities that are already thoroughly regulated. The concern being that 1470 would impose redundant and possibly conflicting requirements. Just to be clear, the proposed amendment will mirror language that was previously approved in HB 1090. So nothing new, but just ensuring that consistency and clarity. I'm happy to try to answer any questions if you have them.
Yep. Senator Benke.
Thank you, Madam Chair. Are you referencing an amendment coming to us? Because we don't see that right now. Is that what you're referring to?
Correct. We're working on amendments. The governor's office is working on amendments with DOH and DSHS, which I believe the person speaking on behalf of DOH was referring to during her testimony as well. Same amendment, just to clarify, using language that was already approved in the 2021 bill.
All right. Any other questions? Thank you so much. Thanks for being here. Yep. And we have one more panel, 2 in person and 1 remote. Vice Chair Kaufman.
So we have Karina Perez-Gonzalez, Christina Walker, and Hannah Warner.
Good morning.
Good morning, Chair. Good morning, Chair Wilson and members of the committee. My name is Karina Perez Gonzalez, and I am an accredited representative at the Northwest Immigrant Rights Project. I'm here to testify in support of 1470. The first time I went to the GEO private detention facility in Tacoma was in 2011 to visit my aunt. I saw the physical and emotional toll the facility took on her. She was denied dietary restrictions request. There were long wait times for medical visits, and the cost of phones prevented us from speaking to her frequently. Fortunately, my aunt was released, but the conditions in the facility have not improved. Now that I have worked at NERP for the past 6 years, I have witnessed client by client how the poor conditions of the facility have negatively affected the overall well-being of my clients. That leads to negatively affecting their legal case. I had a client, a strong woman with severe medical conditions that stem from being subjected to human trafficking. But she was not receiving the adequate medical care that she needed. She filed multiple grievances and requests and was not being transported to the hospital until she started bleeding, where she underwent surgery. Then she received post-surgery instructions from the doctors and dietary restrictions, but back at the detention center, they were not being followed. In addition, my client was also placed in solitary confinement, where she describes losing all hope and wanting to give up on her immigration case. My client told me that she could not stay detained longer because she felt like she was slowly dying. So after years of enduring negligent medical care, years of poor diet, and insults from the guards, my client was forced to make the decision to stop fighting her case and was ordered removed. Soon after, we received notice. We found out that the Board of Immigration Appeals had actually granted a low bond amount. So had my client received adequate living conditions in the detention center, she would have been able to pay for that bond and she would have been released. We urge your support for 1470 because our community members and family members that are detained at private detention facilities deserve fair and humane treatment.
Thanks for being here. Appreciate your testimony this morning. And we are going to go to Hannah. Good morning.
Thank you. Good morning. Good morning, Chair Wilson and members of the committee. My name is Hannah Warner, testifying on behalf of Columbia Legal Services in support of Second Substitute House Bill 1470. This bill requires a set of baseline health and safety standards in private detention facilities in the state. Courts have made clear that the state can regulate health and safety within private facilities, even if the facility has a contract with the federal government, in order to protect residents and ensure compliance with basic conditions, such as sanitation and adequate nutrition. We appreciate the strong engagement that we've had thus far with stakeholders, including our state and local agencies, to craft a bill with an efficient oversight system consolidated under the Department of Health that will keep facilities in our state accountable. This bill is vitally important to protect the basic human rights of the most vulnerable members of our community. We look forward to continuing work with stakeholders to strengthen and move the bill forward. We urge this committee to support this bill. Thank you.
Thank you, and thank you both for being here this morning. And our last individual to testify on this bill, and then we'll close the hearing on Second Substitute House Bill 1470, is Christina Walker, Deputy Mayor, City of Tacoma. Good morning. Thanks for joining us.
Good morning. Can you hear me okay?
You're good. Yes.
Okay. Good morning, Chair Wilson, Ranking Member Bienke, and committee members. I am Tacoma Deputy Mayor Christina Walker. Thank you for the opportunity to testify in support of House Bill 1470. As city leaders in Tacoma, we share the concerns expressed by local community advocates for the health, safety, and welfare of detainees held locally at the Northwest ICE Processing Center. House Bill 1470 takes important steps to ensure that state health and safety standards are followed at the detention center and provides for the basic needs of people held in this facility. As you are aware, the Northwest ICE Processing Center is located in Tacoma and is the only for-profit immigration facility operator in Washington state. For the past decade, community members and detainees have raised significant concerns about food quality, sanitation, safety, punitive use of isolation, and more recently, a lack of protocol to prevent the spread of COVID-19. Just recently, we learned of a case involving the serious disregard of a person held in the NWIPC that involved the unnecessary use of solitary confinement that resulted in the person requiring medical care. We take these concerns very seriously. However, currently we are unable to respond to the needs of the people who are residing in the NWIPC, which is in our community. House Bill 1470 provides transparency, oversight, and accountability to ensure the facility in our city is providing adequate care and treatment of the people in the NWIPC. We support the amendments made in the substitute and ask that you pass this bill out of committee. Thank you so much for the opportunity to testify today.
Thank you, and thanks for being here. Appreciate your testimony. That closes the hearing on Second Substitute House Bill 1470, and we